Good afternoon. My name is Renee Townsend, and I'm a partner at Seacrest Wardle. Today's presentation is on the premises liability topic of the Trespass Liability Act. This topic will include a review of the common law duties imposed on landowners when it comes to trespassers and the effect of the recently enacted Trespass Liability Act, which is at MCL 554583. We begin with a very basic and quick review of the common law duties owed by premises possessors to those on their land. In a premises liability suit, the duty of care owed by the property owner or possessor depends upon the plaintiff's status of the land, on the land. So historically, Michigan has recognized three common law categories for persons who enter upon the land or premises of another. Each of these categories corresponds to a different standard of care that is owed to those injured on the owner's premises. The highest level of duty owed to an individual on someone's property is to invitees. A landowner owes an invitee a duty to use ordinary care to keep the premises in a reasonably safe condition. In fact, a landowner has a duty of care not only to warn the invitees of any known dangers, but the additional obligation to also make the premises safe, which requires the landowner to inspect the premises and, depending on the circumstances, make any necessary repairs or warn of any discovered hazards. So an example of that would be like a business customer. The next level of legal statuses is licensees. A landowner owes a licensee a duty to use ordinary care to prevent injury arising from the landlord's active negligence. This includes a duty to warn the licensee of any hidden dangers the owner knows or has reason to know of if the licensee does not know or have reason to know of the dangers involved. The landowner owes no duty of inspection or affirmative care to make the premises safe to the licensee's visit. So that's the difference between that status and the invitee status. An example of licensee status would be a social guest. Finally, the lowest level of legal status on the land is that of a trespasser. There is generally no duty owed by a landowner to trespassers under the common law. The landowner owes no duty to the trespasser except to refrain from injuring him by willful and wanton misconduct. But what is a trespasser? A trespasser is a person who goes upon the premises of another without their express or implied permission, for his own purposes, and not in the performance of any duty. A trespasser need not intend to be a trespasser to be considered one in a civil case. This is different from criminal cases. Intent does not matter. If you're on someone else's land without their express or implied permission, for your own purposes, and not in the performance of any duty, you're a trespasser even if you don't mean to be. Under most circumstances, under the common law, landowners have no duty to keep their premises safe for trespassers. That means there's no duty to make the premises safe or to warn of any dangers, even if they are known to the landowner and could not be known to the trespasser. There is, however, a duty not to actively harm the trespasser. So, for example, you cannot set traps. A landowner could not set a hipster trap on his property and sit back and watch the bearded, skinny jean wearing musician next door wander into it. All of these statuses and corresponding duties arise from the common law in Michigan. However, we're here to talk about the statutory duties owed to trespassers and the statutory protections available to landowners. Effective June 26, 2014, the Michigan legislature codified property owners' tort duties with respect to trespassers in MCL 554.581 et seq. The statute states that a property owner or possessor owes no duty of care to a trespasser and is not liable to a trespasser for physical harm caused by the possessor's failure to exercise reasonable care to put the land in a condition reasonably safe for the trespasser, or to carry on activities on the land so as not to endanger trespassers. There are some important express protections for landowners in the statute. The statute does not increase the liability of a possessor of land and does not affect any immunity from or defenses to civil liability established by or available under the statutes or common law to which a possessor of land is entitled. The statute codifies protections for landowners, but does not alter the general rules regarding trespassers under the common law in any significant way. But now that we've said that, we have to talk about the exceptions to the statute. As with most statutes, if you discuss the rule, you have to discuss the exceptions to the rule. MCL 554.583 sets forth 4 specific exceptions under which a possessor of land may be subject to liability for physical injury or death to a trespasser under the Trespass Liability Act. Number 1, if the property owner engages in willful or wanton misconduct. Number 2, the property owner is both aware of the trespasser's presence and is actively negligent. Number 3, the property owner knew or should have known that trespassers constantly intrude on a limited area of the land, and the trespasser was harmed as a result of the possessor's failure to carry on an activity in that limited area involving a risk of death or serious bodily harm with reasonable care for the trespasser's safety. And number 4, in certain situations where a child is injured by an artificial condition on the land. Now that last one comes with its own set of sub-requirements, all of which must apply for a landowner to be liable for a child injured by an artificial condition on the land. So basically, when children are involved, a special rule imposing a higher degree of care may apply. I call this the dumb kids rule, though that's not the official name. What the dumb kids rule basically says is that a landowner is required to take into consideration that a child's ability to appreciate the full extent of the risk is different from that of an adult. This may be familiar to some as part of the attractive nuisance doctrine. Under the Trespass Liability Act, a landowner may be liable for a child injured by an artificial condition on the land if all 5 of the following conditions apply. Number 1, the possessor knew or had reason to know that a child would be likely to trespass on the place where the condition existed. Number 2, the possessor knew or had reason to know of the condition and realized or should have realized that the condition would involve an unreasonable risk. Number 3, the injured child, because of her youth, did not discover the condition or realize the risk involved in intermeddling with it or in coming within the area. Number 4, the utility to the possessor of maintaining the condition and the burden of eliminating the danger were slight compared with the risk to the child. And then finally, number 5, the possessor failed to exercise reasonable care to eliminate the danger or otherwise protect the child. So it may be hard to see, but I've included a picture of an old rusty slide going directly into a dumpster. I don't know why this picture was on the internet, but I found it. Let's say this slide is in an area known to be used by neighborhood kids to walk to their elementary school. This would be an example of a situation in which a landowner will likely find himself liable under MCL 554.583 subsection 3. If you go through all of those requirements, all 5 requirements, and apply this particular situation, you'll understand how the landowner would become liable in this case. So, number 1, that the possessor knew or had reason to know that a child would likely trespass in this area. Well, we said that this is a route commonly known to be used by elementary school children to get to school. So that satisfies number 1. Number 2, that the possessor knew of the condition or should realize that it had an unreasonable risk. I think just by looking at this condition, you can see that this involves an unreasonable risk of harm with the missing steps, kind of crickety slide going right into a dumpster. Number 3, that the injured child, because of her youth, did not realize the risk involved in coming into the area. So we're talking about elementary school kids. If we're talking about middle school kids, you might have a better argument to say someone who's 13 or 14 might have a better understanding of the danger. But if you're talking about 5, 6, and 7-year-olds, you will probably end up liable in this situation. And finally, number 4, the utility of the possessor maintaining the condition and the burden of eliminating the danger were slight compared with the unreasonable risk to the child. So I can't really think of a situation where putting a slide into a dumpster would really have any utility to a possessor. And if you look at the burden of eliminating that, just take it down, maybe throw it into the dumpster. That satisfies number 4. And then finally, that the possessor failed to exercise reasonable care to eliminate the danger or otherwise protect the child. To apply that to this situation, if you put up a fence or some kind of apparatus to block those steps off or something, you're at least showing the court that you've done something that was reasonable to eliminate the danger to protect the child. There are just a few other housekeeping matters regarding this particular statute. The Trespass Liability Act is effective as of June 26, 2014. The statute does not specifically state that it applies retroactively, so it is presumed to apply prospectively to all accidents occurring on or after June 26, 2014. It will not be applicable to accidents before June 26, 2014. This is something to watch out for in complaints that may include a statutory trespass claim. So if someone's trying to apply it to, let's say, a 2013 accident, it should not be applied. The Trespass Liability Act does not define the term trespasser, so it's presumed to rely upon the common law definition that we discussed earlier in this presentation. And then finally, the general lesson to really take from this presentation is that the Trespass Liability Act states that there's no duty of care owed by possessors of land to trespassers with some exceptions. And within those exceptions, there are special considerations for trespassing children. We've reached the end of the presentation. I hope that this information has been helpful to you and gives you a better understanding of the duties, obligations, and protections afforded to premises possessors for claims by trespassers under the common law in Michigan and now the Trespass Liability Act. If you have any questions, please do not hesitate to contact me. My contact information is now on the screen, or you can look me up on our website, www.seacrestwardle.com, or on LinkedIn by my name. Enjoy the rest of your day, and thanks for taking the time to view the webinar.